You've just been sued. Your heart's pounding, your lawyer's promising to fight for you, but deep down, you know how this works. Even if you win, you still lose. There's legal fees, frozen assets, the risk of a massive judgment, and the sinking feeling that your financial life is no longer in your control. So let me give it to you straight. If you already own something, liquid capital, real estate, brokerage accounts, crypto, and you don't have protection in place right now, you're not safe, especially if you're trying to rely on a US-based asset protection structure. Because here's the truth. If it's inside the US, a US judge can take it. So let's talk about what actually works. How you can still legally protect what's yours, even if you're already in litigation. Hi, I'm the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been helping clients shield their assets from lawsuits for over 34 years. And when litigation hits, our legal firepower steps in to do one thing, and that's protect what's yours. Now let's get to the good stuff. People love to talk about asset protection strategies in the US, LLCs, limited partnerships, charging orders, even domestic trusts in states like Nevada or South Dakota. And don't get me wrong, if you're planning ahead, those can be part of your strategies. We set those up too, because the moment you're sued, all bets are off. Because here's what your attorney won't tell you. A US judge can reach into any US entity and seize the assets, period. They can compel you to distribute funds from your LLC. They can order you to revoke a domestic trust. Believe me, in 34 years, I've seen everything. They can force your hand with contempt charges if you refuse. So let me give you a real example. In 2013, a case in the matter of Huber, a real estate investor named Thomas Huber, created a domestic asset protection trust in Alaska. Now, Thomas lived in Washington State, a state I used to live in. He moved millions of dollars in assets into the trust to shield them from creditors. But when his financial troubles led to bankruptcy, the court didn't honor the Alaska laws. That's pretty normal. I see it all the time. Instead, it applied Washington state law. And under Washington law, the court found that the transfers into the trust were fraudulent conveyances. The result? The court unwound the trust, exposed the assets, and allowed the creditors to grab everything. I mean, after all, the trust, the trustee, the assets were all in the US under the jurisdiction of the US judge. So this case proves something critical. Domestic trusts are only as strong as the court that's reviewing them. And when you're already in litigation, U.S. courts will almost always side with the creditors, especially when it comes to intrastate trust protections. But here's the good news, and we're not talking theory here, we're talking about legal, proven, court-tested structures that work where U.S. courts lose their grip. Offshore asset protection trusts. And not just any offshore structure, because most countries don't have the backbone to stand up to U.S. judges. But two stand out: Cook Islands trusts and Belize trusts. So let me explain exactly how we build these, and listen closely, because this is the same strategy we've used to protect real people, real assets, and real lives. And like I say, I've been doing this for 34 years. So here's how we build the wall between you and your lawsuit. First of all, we start with a Cook Islands trust or Belize trust, depending on your situation. Typically, if the litigation is progressed too far, we need to go with Belize because the Cook Islands trust aren't too friendly with people who are already in litigation, especially if it's a big case. So that's why it depends on the situation. So this is the core legal shield. Offshore trusts in these jurisdictions are governed by their own local law and not U.S. law. And they don't recognize U.S. judgments. And then we place inside of the trust a Cook Islands LLC or Belize LLC, owned 100% by the trust, controlled initially by you as the manager. Now that's important. When the waters are calm, you stay in control. And then we open a Swiss bank account in the name of the LLC that's inside the trust, that is, not in your personal name, and not in a bank that caves to U.S. court pressure. Now, we also set this up for people in Canada, Australia, New Zealand, people all over the world. So it's not just U.S., even though I mentioned the U.S. a lot here. So here's the magic. The moment the lawsuit hits, our licensed, bonded offshore trustee company law firm steps in. You're removed as manager of the LLC, and they step in protecting assets from seizure. This means your assets are no longer under the control of the U.S. courts, which is exactly what makes it legal and effective. Because no U.S. judge can compel a foreign trustee company. They have no jurisdiction in the Cook Islands, no leverage in Belize, and no ability to freeze funds in a properly structured Swiss account under the offshore LLC that's in the trust. And that's the difference between theory and actual protection, and we've seen it stand up over and over and over again. In fact, we've never seen a client lose money from a judgment that had their money in one of our Cook Islands trusts. And that's significant because we've set up more Cook Islands trusts than anybody in the world. So let me tell you about Peter, a real client, a successful entrepreneur in New York, got blindsided by a business partner who turned into a bitter enemy. Lawsuit filed, claimed $3.2 million in damages. Peter had $2.1 million in liquid capital as brokerage, bank, crypto, and then he came to us 3 days later after being served. So what we did in his case is we set up a Belize trust with a Belize LLC, and then we moved his liquid capital into a Swiss account. So we moved his cash, his stock, his crypto, all to the Swiss bank, and then opposing counsel found out. They screamed, fraudulent transfer! Now keep in mind, fraudulent transfer is by and large a civil matter, not a criminal one. It has that scary word, but it's still a civil matter. It's just a term for the civil act of moving assets away from a creditor. In some jurisdictions it goes further than that, but it's typically a civil matter in most jurisdictions. But here's the kicker. Belize doesn't care. They don't care about fraudulent transfer. In the U.S., the statute of limitations on fraudulent conveyance in Belize is non-existent. The assets are protected right away, and they don't recognize U.S. court judgments. So Peter never lost a dime. Or take Sandra, another client, a cosmetic surgeon in California, got sued by a former patient for malpractice, one of those gray area cases where winning wasn't guaranteed. I mean, after all, the patient didn't follow the post-surgical instructions, which caused the problem. So what we did is we set up a Cook Islands trust with a Cook Islands LLC inside, got her $1.6 million in savings into a protected offshore structure, set up a Swiss bank account. When she lost the case, the judgment creditor got nothing, zero. And no, that's not a loophole, it's the law. Okay, now if you're watching this and you haven't been sued yet, but you're worried that you could be, listen closely. The best time to set this up is before the lawsuit is filed. Why? Because 1, it's less expensive. 2, it's cleaner. Next, there are fewer legal hurdles and less scrutiny. And most importantly, the longer the asset sits inside the trust, the stronger the protection becomes. Remember, most asset protection structures are only challenged under the claim of fraudulent transfer. But if the transfer occurred before there was even a threat of litigation, it's nearly impossible for them to challenge. And that said, if you've already been sued, there's still time. Yes, it's more expensive to set it up after you've been sued. Yes, it's more urgent, but it's not too late. We've done this many times, and this is called the high risk fee because we're more likely to get drug into your problem because you're not buying theory, you're buying real world firepower when it matters most. Okay, now the important side note. Divorce is a completely different animal. The moment your spouse files for divorce and you're served with those papers, a financial restraining order kicks in. So this means that you are legally forbidden from moving any assets even if they're yours. So if you're worried about a divorce, don't wait until after the papers arrive. We've seen too many people call us after being served with divorce papers, and by then, the options are limited. We will likely not even take the case. You might already be frozen out of your accounts, and any move could be deemed illegal. So if a divorce is even a possibility, you need to act now before the papers come. And trust me, it's the smartest thing you'll ever do. Okay, now let's talk numbers. This is not for somebody trying to protect 60 grand in a savings account. Offshore protection structures involve legal professionals, foreign trustees, international banks, and they're not cheap. We typically recommend offshore asset protection for anybody with $500,000 to $1 million or more in liquid or semi-liquid assets. Real estate owners with equity they can't afford to lose. And we use additional strategies, by the way, with real estate because we need to do equity stripping, land trusts, LLCs, and so on. Entrepreneurs, physicians, business owners, or crypto investors. So people in high-risk professions like construction, finance, or tech are other examples of people who can use offshore trusts effectively, and anybody already facing litigation, staring down a judgment who has significant assets. So the total setup, including the trust, the LLC, the trustee, international banking, typically starts around $25,000 25 to 26,000 up to 50,000, depending on your situation, what additional structures that you need. So that's not pocket change. But if you're facing a $1 million lawsuit, a vengeful ex-partner, or a 6-figure lawsuit that could wipe out your entire savings, it's the best money you could probably ever spend. So let me get this clear. You're not hiring a theory. You're not buying a book or a cookie cutter template online. Instead, you're getting access to a real time-tested network of licensed attorneys, our U.S. law firm, our offshore law firm, bonded trustees, international banks, and my 34 years of proprietary legal know-how. So we don't outsource, we don't guess. We've done this more than any firm on earth, especially when it comes to Cook Islands trusts. So when something goes wrong, don't panic, we execute. Okay, so let me address a question that some people are too shy to ask. Is this ethical? And the answer is absolutely. You're not hiding money, you're not evading taxes, you're not stealing from anyone. You're legally separating your personal assets from legal threats. And that said, I might as well add, if somebody did steal money, we wouldn't accept them as a client because we're not going to protect stolen assets. We only protect legally obtained assets. And as you know, doctors carry malpractice insurance, CEOs have indemnification, passengers have seat belts, and you have a trust. And the best part, this protection doesn't defend you in one lawsuit. It really becomes a lifestyle, a permanent legal firewall, because once you're sued, you're probably going to be sued again and again and again. Most business people are sued multiple times. Okay, so if you've been served, don't wait. Every day that passes gives the plaintiff's attorney more time to dig, more opportunity to freeze your assets mid-lawsuit. If you haven't been sued, but the threat is looming, this is your wake-up call. This is your golden window. I mean, you only have a limited time to do this. And if you're facing divorce, get ahead of it now, or you may have no options left. So if you find this video helpful and you want more real-world strategies to protect your assets and protect what you've built, make sure to subscribe to this channel if you haven't already. I post videos weekly to help high net worth individuals, entrepreneurs, and business owners guard their wealth from lawsuits, excess taxes, legally, and life's curveballs. So when you're ready, visit us at assetprotectionplanners.com. You can fill out a free consultation form or call us. We'll walk you through exactly what's possible in your situation if you have significant assets and you're serious and not just curious. Because here's the truth. The court system isn't built to protect you. We are. So when the storm hits, it's not your attorney who saves you. He may be able to help you defend a case, but it's not who saves you. It's the structure that you already put in place is what saves you. So protect yourself now or risk paying the price later. This is The Business Guy.